which create a sandwich. One directive says that if you file an application or petition and it does not have all the necessary documents, if it doesn't have all the supporting documents, the Immigration Service should not ask you to provide the missing documents. For example, if you file an application for adjustment of status, and at the time of filing the application, you do not include the affidavit of support, or you include a deficient affidavit of support, or you do not include your own certificate of birth. Until now, the Immigration Service used to send you a request for evidence and give you time to complete the missing document. Come as the Immigration Service now and says, oh no, why waste time? If you don't submit a complete, perfect application, we will immediately deny it.
Wow.
And this is even before you ever get to an interview. Because this will be a denial that comes from the completeness review when your application is taken in.
Wow.
When the application is taken in, the first thing they do, after they cash your check, of course, is do a completeness interview. Is it a complete application?
Right.
If they find it's not complete, just deny it.
Wow.
Don't send any request for evidence. So this is one directive. The second directive is that if you go for an interview, and this could be an interview for adjustment of status for a green card, or an interview for citizenship, or maybe any other kind of interview, and the immigration officer finds a reason to deny you, they should immediately issue a notice to appear in immigration court for deportation.
Wow.
Previously, most denied cases were not subjected automatically to a deportation process. Most denied applications were just put on the shelf and closed.
Right.
Now they want, they say, we have the authority to start a deportation case immediately, and we will do it. Now, of course, the result of this will be, again, a terrible bottleneck or blockage at the immigration court.
Correct.
Because they cannot handle the present backlog, so they will add a bigger backlog. But this will be a considerable headache for people, especially those people who don't use lawyers. This will be a big problem for people who try to do their own cases or go to consultants, to immigration consultants or notarios, who just file papers without knowing what they are doing. And then they will get surprising notices to appear in immigration court because the applications were incomplete or mistaken or whatever.
That's right.
So this is a set of rules that came out recently from the Immigration Service.
Indeed, it's tough for the applicants now, especially as you said, some people just prefer to do things on their own. Well, principally because people, they always think that they have no money to spare, and so they do the things on their own. It would also be a little bit complicated for the immigration lawyers. I mean, you get the application and perhaps they didn't do it right. Their application is wrong, there are so many mistakes, so it will take a longer period of time, but definitely the lawyers can straighten out their applications. Will you be given the chance or the time, Attorney Golan, to review all those applications when they're given this notice of deportation?
Yes, because in most cases the law provides you the ability to reapply in deportation. Okay. In most cases you have the ability to reapply in deportation. so we'll have the chance to correct all those mistakes.
Right.
Of course, it's a completely unnecessary headache and waste of money.
That's right.
If it could have been done right, correctly from the beginning.
Right. Attorney Golan, what normally do you find are the mistakes of those who do these things on their own in terms of their application?
Look, many people get denied because of procedural errors.
Uh-huh.
Many people do not understand the questions on the forms. Okay? Because the government didn't make a great effort to write clearly.
Mm-hmm.
What they did the opposite. What used to be a petition of 1 page or 1.5 pages, and it now became a petition of 20 pages.
Mm-hmm.
Okay, so the number of questions increased fantastically, and if you don't remember exactly what you answered on page 2,
right,
you can give a contradictory answer on page 16. Okay?
Mm-hmm.
So this is one of the problems. Okay. Also, many people don't take into account that the practice is different than the theory. They read about eligibility online,
right,
and they don't know that the way it is applied is a little bit different.
Mm-hmm.
Okay? It's not exactly the same.
Mm-hmm.
So this is the type of mistakes people do.
Mm-hmm.
Now, one other mistake is that some people apply without being eligible, which
see.
is a complete foolishness.
Right.
Because if people come to me and I find they are not eligible, I don't make an application.
That's right.
Because this will be a waste of time and money and putting the client in harm's way.
Correct. Uh-huh.
But some people just make such applications.
Mm-hmm. Attorney Golan, what about the documentation? If it's incomplete, will you have enough time for them to be able to look for those documents?
Again, depends what is going on. Okay, depends how it is going on. Depends whether we are under a deadline or not.
Mm-hmm.
Okay, I'll give you an example. Many people, quite a few people, got green cards successfully, and then the time comes to apply for citizenship.
Mm-hmm.
And when they got the green card, they had the assistance of a lawyer, or they had the assistance of Lady Luck. Okay? and they got the green card. Okay, now they think that applying for the citizenship will be a snap, and they don't use a lawyer for the citizenship.
Right.
And then they get a denial. Because today, again, one of the new procedures in immigration is that when you apply for citizenship, they pull out your green card file and review and recheck everything in your green card application.
Mm-hmm.
So now all of a sudden, to their great surprise, they get a denial of the application for citizenship with some very alarming accusations.
Mm-hmm.
And then they come to us, okay? They come to us, and the denial notice always says that you have 30 days time to request a review of the denial. Many times after I look at the denial and understand the history, I tell them, look, let us not do a review of the denial, because it will be useless, and we don't have time to prepare a better application in those 30 days, because usually when they come to me, half of the 30 days are already gone. Instead, let us make a new application for citizenship.
I see.
So there is no deadline for this.
Mm-hmm.
We can spend 1 or 2 or 3 months preparing the new application and preparing the necessary documents to support the new application, and then we'll go ahead and do it. And there is not much difference in costs between doing this or doing that. So forget the review of the denial. Let's do a new application.
I see. So the immigration will not compare what was put in the application that was denied with the new one. I mean, we say looking at inconsistencies.
Yes.
Yes,
they will, absolutely.
Wow.
Nothing gets lost. Nothing gets lost. Nothing gets forgotten.
I see.
But maybe in the new application and the supporting documents, we have good explanations for what they did not like in the first application.